Okay, good morning, everyone. I, it looks like everybody who was in the waiting room is now in, so we'll go ahead and get started. I'm Alan Lilly, presiding hearing officer of the State Water Board's Administrative Hearings Office, and I'll be running the hearing today. Just on the logistics here, most of you appear fine. I do see for Deirdre, we just have your first name. So I'll ask my staff to change that to Deirdre Walsh. So we have it. It just makes it a little better for the recording if we have first and last names. And for Taggart and Taggart, can you just identify who, I see both of you in the picture, but can you just identify who you are?
Yeah, hi, good morning, Mr. Lilly. My name is Tim O'Connor. Yeah, we do Paul Taggart.
Okay, so good morning, Mr. O'Connor and Mr. Taggart. Otherwise, everybody looks like everybody's on board. My staff members, Amy Blanc, Skylar Anderson, and Nicole Kunze are helping me, but they probably will not appear video or audio unless I have questions for them, just so you know that they are on the recording as well. And the other people who have not appeared, I see Neil Favor, Kelsey Swagger, looks like Vanessa Merzian, and Ray Sahlberg. You can appear by video if you want to. If you want to just stay on mute, that's fine as well. And of course, if you speak, I'd like you to appear on video if you have video going. So with that, let's go ahead and get started. As I said, I'm Alan Lilly, and I'll be running the hearing today. As we stated on page on section 12 on page 19 of the March 24 hearing notice, the Administrative Hearings Office has not ordered a court reporter for this hearing. Any interested party had the opportunity to order a court reporter, but as far as I can tell, nobody did. We will use the Zoom recording, video plus audio, as our official record for the hearing today. So for the parties and attorneys who are appearing today, first of all, Mr. Taggart, if you could enter your appearance, please.
Yes, my name is Paul Taggart. I'm here on behalf of Trimont, and with me is Tim O'Connor from Taggart on behalf of Trimont as well.
Okay, and Mr. Taggart, I don't know if there's anything you can do about it. We have a pretty bad echo from your audio. It's just, I mean, it sort of sounds like it's echoing through the conference room. So if there's anything you can do to fix it and make it easier for us to understand you, but if you can't, we'll bear with it. It might be when you speak, if you want to just be a little closer to the computer, that might help. Why don't you try that and see if that works better?
Is this any better?
That's a little bit better. There's still some echo, but we'll go with the flow on that.
Yeah, we're in an old building and it tends to have bouncing acoustics.
Yeah. Okay. Well, I can understand you. It's just there's a little bit of a buzz, but that's fine. And then Mr. O'Brien, I assume, or could you please enter your appearance here this morning?
Yes, good morning, Mr. Lilly. Kevin O'Brien, representing Northstar Community Services District. And I'll ask my colleague Austin Cho to introduce himself. Mr. Cho will be taking the lead this morning.
Oh, okay. Mr. Cho.
Good morning, Mr. Lilly. Austin Cho on behalf of the Northstar Community Services District, one of the petitioners in this hearing.
Okay. Okay, and then it looks like everyone else are people who have submitted testimony as witnesses. So I will ask you to speak when we get to you, and we'll administer the oath and do all the things we need to do for testimony. So I think most of you participated in the pre-hearing conference in this matter. As I said there, please refer to me as Mr. Lilly, and I'll refer to you as Mr. or Ms. with your last name. This is not a court proceeding, so you do not need to use your honor. Please don't. But I do want to keep it a little bit formal, just because it is a formal hearing. Does anyone have any questions about the hearing process before we proceed?
Yes, Mr. Lilly, this is Tim O'Connor. Can you hear me okay?
Yeah, you still have the echo. I can understand you though, so go ahead.
Does this solve the echo at all if I come down here? Or am I still
That's- It's better, but it does not eliminate the problem.
Okay. I just have one piece of housekeeping before we get going regarding evidence. We anticipated moving the testimony pieces of evidence in with every witness, as we had discussed earlier, and then requesting to move all the evidence sort of as a big lump at the end after the testimony pieces. And so that was our plan, and I wanted to run that by you before we kind of got going here in earnest today.
Yeah, I think that'll be fine. Obviously, it's good to have the witnesses testify to authenticate the evidence first, and then we'll admit the evidence into evidence. So if I forget, please remind me. And before we end the hearing, I want to make sure to give you an opportunity to offer the evidence, offer the exhibits into evidence. But it's going to be a lot easier since we don't have any other parties. We should be able to get through it okay. But thank you.
Sure. So you would like each witness to authenticate each piece of evidence? I'm sorry, a witness to authenticate each piece of evidence as opposed to authenticating the lump of evidence?
Well, let's play it by ear. I think most of the exhibits were referred to in some witnesses' testimony. So that will authenticate those. If there are any that's not the case for, we'll see. We can be pretty informal since we don't have any party objecting to this. So I'm not too worried about that. But I do want to have a record where everything's authenticated. I think that's in your interest as much as mine.
Absolutely. Okay, thank you.
So, all right. So as I said during the pre-hearing conference, I think this hearing can be fairly short since we don't have any adverse parties who are participating. I will give you each of the attorneys an opportunity to make a brief opening statement. And then I'll ask each witness one by one to take the oath and confirm that their written proposed testimony is in fact their testimony. And then I will ask some questions, and I do have questions for the various witnesses. And then after that, of course, if the attorneys have any follow-up questions, that's fine. I think there is going to be a need for some additional briefing and testimony based on my review of the exhibits that have been submitted in the proposed order. So we'll cover that as well. And again, this is as much in your interest as in mine that we have a complete record that supports a proposed order that the State Water Board will adopt. Obviously, that's the goal here. So any questions about that procedure before we go forward? All right, so we'll proceed with opening statements. Mr. Taggart or Mr. Cho, whichever one, if you want to give an opening statement, whichever one of you wants to go first, please go ahead.
Mr. Lilly, I would offer to waive an opening statement at this time unless you prefer to hear something from me, but I prefer to just have our witnesses go ahead and enter their evidence into the record.
And that's fine with me. Mr. O'Connor, Mr. Taggart, do you want to make an opening statement or not?
Again, I'm going to defer to Mr. O'Connor. He's going to be leading the presentation today.
Okay, Mr. O'Connor.
And Mr. Lilly, we will also waive the opening statement, and we're ready to present our first witness when you are ready.
All right. Well, I'm going to just go ahead and take it from the top in the order of the exhibit numbers. So the first witness, exhibit Trimont Northstar 1, is Deidre Walsh. So maybe Mr. O'Connor or Mr. Taggart, you can go on mute because we are getting a little bit of feedback from you now. Good. All right. So Ms. Walsh, if you can go off mute and raise your right hand, please. Do you swear that the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth? Under penalty, let me try that one again. I got it wrong. Do you swear under penalty of perjury that the testimony you will give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
All right. And I'm going to just make this go fairly quickly. Is exhibit Trimont Northstar 1 your written proposed testimony for this hearing?
Yes.
All right. And normally we have witnesses summarize their testimony. I don't think that is particularly necessary here unless there's something you want to say about it. I have read it, and as I say, there are no other parties. So is there any, do you have any comments, or can we just go ahead and proceed that way?
No comments to add.
All right. All right. So then we will go to Mr. Martin. Mr. Martin, are you here?
Yes, I am here.
All right. Please raise your right hand. Yeah, move it into the screen so we can see it there. Do you swear or affirm under penalty of perjury that the testimony you will be giving in this hearing is the truth, the whole truth, and nothing but the truth?
I do.
All right. Thank you. And then I have exhibit Trimont Northstar 2. Is that in fact your written proposed testimony for this hearing?
Yes, it is.
All right. And do you have anything you want to add or summary to that, or can we just enter that into evidence?
I have one correction for you.
Okay, please let me know what that is.
Okay, that is footnote 2 on page 3 contains an incorrect reference to an exhibit D that was not submitted. The reference exhibit D in footnote 2 is actually already part of the hearing record as noted in footnote 1 on page 2.
Okay, so how should we edit that text? Where it says attached here to as exhibit D, what should we say instead?
Mr. Lilly, that entire footnote number 2 could be stricken from the testimony as it's referenced earlier in the testimony already.
All right, I'm going to just cross it out, and for the record, we will note that for Mr. Martin's testimony, footnote 2 will be deleted from the written testimony for the actual testimony he's giving at the hearing. So, Mr. Martin, anything else?
No other comments. Thank you.
All right, we'll go forward with Mr. Wagner. Mr. Wagner, please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you will be giving in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
And is exhibit Trimont Northstar 3 your written proposed testimony for this hearing?
It is.
And do you have anything that you want to add to that testimony, either in summary or corrections?
I don't believe so.
All right, thank you. Let me make sure I'm not missing anything here. I'm going to move to Miss Diane Wagner. Miss Wagner, please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you will be giving in this hearing will be the truth, the whole truth, nothing but the truth?
I do, yes.
Thank you. And is exhibit Trimont Northstar 8 your written proposed testimony for this hearing?
Yes, it is.
And do you have anything you want to add in the way of summary or corrections to this proposed written testimony?
Not at this time, no.
All right, thank you. And I think those are all the witnesses. Is that correct, Mr. Cho and Mr. O'Connor?
Yes, Mr. Lilly. Aside Mr. Martin, we have Joshua Detweiler, who is also employed by Northstar Community Services District. He's available to help support if there are any clarification questions or answers that he might be able to assist on. He was included in our notice of intent as a potential witness, but we determined it was not necessary to submit written evidence on his behalf.
Okay, well, thank you, Mr. Cho. And Mr. Detweiler, just in case I ask you some questions, let's get it over with now. Please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you will be giving in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. All right. Well, with that, I do have several questions that I would like to go through now, and some requests. So let me do that. And if anyone has any objections, please just state them, although I think these are fairly straightforward questions. And then if Mr. O'Connor and Mr. Cho make notes, and if there's anything you want to add it's in the way of additional questions or arguments after I've asked my questions, please go ahead and do so.
And Mr. Lilly, before you get started, we tried to change a microphone setting here. Does that help at all, or are we worse?
You are much better.
All right.
Whatever you did, it was great. So stick with the new format. Now you don't have any echo at all.
Sounds great. And are volume levels okay?
It's great.
Sounds good.
Yeah.
Thank you. I appreciate
Yeah.
that.
Yeah, for lawyers, you're pretty good with technology unless you had some stealth person helping you.
All right. Well, thank you very much. I appreciate that.
Yeah, no, that's much better. Thank you. Okay, so I'm going to just go down my questions, and they're just going to go in the order of the exhibit. So, Ms. Walsh, I'll start with you. And I'm going to ask my staff to put up exhibit Trimont Northstar 1 on the screen and go to page 9, which will take them just a minute, but they usually get this pretty fast. Okay, good. And if you can, Mr. Anderson, just go to the bottom of page 9 and make the bottom half of the page a little bigger. Excellent. Okay, so yeah, that's fine. Thank you. So, Ms. Walsh, in reference to question 20, this asks about the water infrastructure needs and potential building of Reservoir B, which may be necessary for delivering peak water delivery demand at full build out. Do you see that?
I do.
All right. So my question is, the petitions for extensions of time ask for extensions through 2028, I believe, and in particular the one for permit 15905. And I just am wondering, is it really very likely that this reservoir will be built and applied to full beneficial use by 2028? That being roughly 6.5 years from now.
As far as Reservoir B is concerned, we haven't put any resources into understanding the feasibility of that permit because it's been in limbo. So we do have our plans related to the 2017 Northstar Master Plan that would require Reservoir B to be adequate against those needs for that build out. But due to the in limbo effect of this permit, we don't have a feasibility study at this time.
Okay. All right. Well, thank you for that clarification. I'm going to probably at the end ask the attorneys to provide some additional briefing on this issue. I mean, I'll be candid. I don't make the final decisions here. I just prepare a proposed order, and the board decides whether or not to adopt the proposed order. And I think they're going to have some questions about this permit 15905 because there's never been any diversion or use under it. And then there's the question about what are the future plans. So when we get to that, I will just mention that to the attorneys that I think we're going to need some additional briefing to support an order for the extension of time for that permit. So thank you, Ms. Walsh. Those are the only questions I have for you, at least for now. And if we can go to Mr. Martin and exhibit Trimont Northstar 2, Mr. Anderson, if you can put that up on the screen and go to page 4.
I'm on page 4.
Okay, yeah, he's going to put it on the screen too.
Okay.
Thank you, Mr. Martin. For our recording, it seems to work best if we have it on the screen. And we'll look at, if you can zoom in on paragraph 12 there. One more click there. Excellent. Thank you. The question I have, and this, and Ms. Walsh may need to answer this as well, but I just was left wondering when I was reading over all these exhibits about the respective roles of Northstar CSD and Trimont Land Company. As I understand it, the testimony says it's a unified water system, and that the water is, as it says here in this last sentence of paragraph 12, that Northstar CSD and Trimont Land Company utilize the water for municipal, domestic, and recreational purposes within the boundaries of the district and Northstar. But Mr. Martin, could you just clarify for me what Northstar CSD does regarding this water system and these permits versus what Trimont Land Company does? And it might be, well, however it is, in terms of purposes of use, places of use, or something else. I just want to get a little better handle on the respective roles of the two entities.
Sure, our role is fairly simple. We're the municipal side of this. So we provide water to the single family homes, commercial businesses. There is water that is provided to the golf course via our system as a metered account. But that's our primary irrigation account. The rest are primarily commercial and residential accounts.
And so just so we're clear, does Northstar CSD then provide all of the irrigation water to the golf course?
We do not provide all of the water. They have a private well as well. So depending on how much water they take from us, it could be, their target, they tell us, is 50% from us currently and 50% from their private well.
Okay, but Trimont Land Company does not supply water to the golf course.
Trimont Land Company does, yes. That's the private well.
Oh, okay, that's operated by Trimont, but that's not subject to these permits.
Correct.
Okay, so then what does Trimont Land Company do regarding the water that is diverted and used under these permits?
That would be the recreational purposes, and Deidre might be able to speak more to that, but as I understand it, they use it for irrigating the slopes in the summertime for recreational purposes, and then making snow in the wintertime.
Okay, Ms. Walsh, do you have anything to add to that?
No, I can confirm that's our uses.
Okay. I'm sorry, I'm writing this down, bear with me. So how again, just a little more elaboration from you, and I need to have some information because I'm going to want to put something in the order because I'm sure the board is going to want to know this distinction. But if it's one unified system, how do the two entities figure out whose water is being used or metered? Or if you want, I'm sorry, I'm not asking this question very clearly, but how do you sort of separate out the functions for things like billing and operations between the two entities? And either Ms. Walsh or Mr. Martin, if one of you can answer that question, and then the other can elaborate if necessary.
I think I can take a shot at it at first, and Deidre may want to elaborate. But so for the NCSD, we meter from exactly which source we're taking from. And it's very clear to us, but we do collaborate a lot as well. We both have SCADA systems. We both have intricate meters that go into that, and we make calculations based on who's using water and where. But for us, it's very simple. We primarily take from the Big Spring cistern, and we know whether or not it's coming from the direction of the reservoir or if it's coming directly from Big Springs itself. And we're very clearly able to meter which source we're taking from at our water treatment plant.
Okay, and then I assume you meter all your deliveries as well?
That's correct.
And Ms. Walsh, if you can just elaborate what Trimont does for metering the water, both at the source and in deliveries.
Mr. Lilly, I don't have that expertise to go into detail on that, but certainly I think our team on the ground, our experts, could provide that information with follow-up.
Okay. But basically, just so we're clear, it's Trimont Land Company is using the system solely for the irrigating the ski slopes in the summer and for snowmaking in the winter.
That's correct.
And do you know if those deliveries are metered?
I would have to follow up on that to confirm precisely.
Okay. I don't know whether or not we'll need that. I'll let you know.
Hey, Mr. Lilly, I'm not sure if you would like me to jump in at any point here to answer some of these as an offer of proof for you, or if you'd prefer to just have follow-up testimony.
All right, well, why don't you do that, Mr. O'Connor? Obviously, you're not under oath, but if you can help me out, that might be useful. Please go ahead.
Sure. So as an offer of proof, as Mr. Martin was saying, there's a fairly complex and detailed metering system throughout the system up on Northstar. So we're able to determine how much water goes into the reservoir, how much is put directly into the snowmaking system, So those different diversions are metered and they're tracked. They're reported every year, as is in the administrative file for those yearly water diversion reports as well.
All right, I'm going to do this just to save us a lot of time. Please just raise your right hand. You obviously have personal knowledge of this. Do you swear or affirm under penalty of perjury that the testimony you will be giving this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
All right. And why don't you please just repeat what you just said about how Trimont Land Company deals with the metering of the water, both taking it from the source and delivering it to the source,
Sure.
to the beneficial uses.
Sure, no problem. So Trimont Land Company, they operate the resort side. You can think of it as the skiing side, the more fun side of the mountain up there. And so they have a disbursement of meters throughout the mountain, as Mr. Martin was saying, and we can use those different meter points to tally how much water goes either into the reservoir system, directly into the snowmaking system or the irrigation system. And from that point, those diversions are used, whether it is to make snow or to irrigate some of those slopes during the summer to maintain them.
All right. And do you have personal knowledge of these things you just testified about?
I have been up to that mountain and seen those metering systems myself, as well as spoken with the on-ground staff out there.
All right. Thank you. All right. So let's go back to you, Mr. Martin. If we can go to page 5 of exhibit Trimont Northstar 2. I think Mr. Anderson can get page 5 of exhibit 2 up here. Good, and that's fine. I just want that top paragraph. Thank you. So, and again, this is just my curiosity. On line 7, it refers to zone 4 of the water system, which of course got me wondering if, Mr. Martin, if you can just explain what zone 4 of Northstar CSD system is, and of course, then that leads to my related question, what are zones 1, 2, and 3?
Yes, no problem. So zone 4 is actually a separate water system from our Northstar water system. We call it the zone 4 water system because we assumed it from PCWA, Placer County Water Agency, and they refer to it as zone 4. So we kept that name. We also refer to it as the Martis Valley water system. It's a separate water system with roughly the same number of connections.
Okay, and it has nothing to do, no water diverted under these permits is used for that system.
Correct.
Okay, so are there zones 1, 2, and 3, or is that zone 4 just a naming artifact?
It's a naming artifact. There are zones 1, 2, and 3 at PCWA, but not for us.
Okay, all right. Well, then I won't worry about zone 4 any further. It doesn't look like it's part of what we're concerned with in this hearing. Okay. So thank you. Those are the questions I have for you, at least for now, Mr. Martin. Mr. Wagner, I did just have one question for you. I don't think we need to pull up your testimony, but your written proposed testimony. But on page 2, question 7, it says, does your engineering stamp appear on this map? And actually, this may be for one of the attorneys to answer instead. But when I looked at exhibit Northstar, or Trimont Northstar 6 and exhibit Trimont Northstar 11, I did not find any engineering stamps on those. And I'm just wondering if you have submitted stamped copies of those maps.
I believe so. If you'll bear with me, the water right map that I stamped is actually as Trimont Northstar 11. And
okay, 11 showed the place of use, or shows the places of use, where 6 shows the diversion, points of diversion and facilities.
I believe, well, let me look here, Mr. Lilly. I think the points of diversion are also on Northstar 11.
Yeah, they are. It just doesn't show it doesn't show, well, I'm not sure. 6 seems to show some additional things, the collection galleries, I think mainly.
I
And
think
it has some
6
insets with the collection galleries.
I think that's right. 6 is more of a facilities map. 11 is the map accompanying petitions that's in compliance with the specific code sections.
Okay, so Mr. O'Connor, have you submitted stamped copies of these maps? Because I just didn't find them.
Yes, Mr. Lilly, I believe Exhibit 11 is the stamped copy that we were submitted that has the different regulatory, requirements on it. Map number 6 is just a facilities map. That's not a, it doesn't have a stamp, I believe, and it's not a map that was submitted for, I guess, regulatory compliance as much as just an explanation of some of those facilities. I think at the end of the day, Mr. Wagner's testimony should be accompanied by Exhibit 11, not Exhibit 6.
Okay, well, so if we do prepare a proposed order for issuing amended permits, we have to decide whether the amended permits should refer to both of these maps or just one. But from what I hear you're saying, you think Exhibit 11 is the only one that needs to be referenced in the amended permits.
Correct. Exhibit 6 should be thought of as just more of an informational document for yourself or the board. Exhibit 11 is really the only map that needs to be referenced in the permits.
Okay, got it. And I do see now, I was looking in the wrong place. I do see Mr. Wagner's certification in the lower left corner of that. Did you submit a large scale copy of this one or just the 8.5 by 11?
I believe it was just the 8.5 by 11, unless Mr. Wagner knows of a different submission that he might have sent in, but we would be happy to send in a different submission or wet signature directly to the board.
Actually, this is all I need. Frankly, I think it's easier just to have the smaller copy. I mean, this is quite legible. And then we don't have the issue of searching for the larger copy somewhere in the water board's files. This can actually just be attached to the amended permits. I think it makes it easier. So we'll go with that. Thank you. That was my bad. I hadn't noticed that the certification was in the lower left. So thank you, Mr. Wagner. All right. So now I'm going to go to Ms. Wagner and starting with Exhibit Trimont Northstar 8. And let me just, you also have some technical memoranda, Ms. Wagner, so that's what I'm kind of jumping. I'm going to just jump around here a little bit, so please bear with me. In Exhibit 8 on page 10, and this question is going to come up in a couple of different places, but Mr. Anderson, yeah, please just zoom in on the first part there. Yeah, that's good. So at lines 11 through 13, it states that your proposed written testimony states the settlement agreement in TROA took into account all existing water rights within the watershed, and even at full build out, the 1,206 acre feet is well within the total amount of water allocated under TROA. Do you see that sentence, Ms. Wagner?
Yes, I do.
And I wondered if you could just elaborate on that. I think when we prepare our proposed order, we're going to need some additional detail on this. So could you just elaborate about the statement about the 1,206 acre feet is well within the total amount of water allocated under TROA?
Well, I don't know if I completely understand your question, but it's my understanding that TROA and the settlement agreement accounts for the water use and existing permits within the Truckee River watershed section. And that amount, 1,206, was the face value of the combined permits. And therefore, has sort of been part of the understanding of TROA, if that makes sense.
Okay, well, I may circle back to this. Let me go to some of your other exhibits, and that may help us elaborate this. And sorry if I'm a little jumbled here, but I'm trying to sort of sort through things. I'm going to come back to that just a second here. So if we can go, come back to 10 and 13. So on exhibit, yeah, so Mr. Anderson, could you please put up exhibit Trimont Northstar 14 on the screen? And we'll go to page 5 of that. Right there is good. So after the table, the text says the estimated depletion at full build out and full beneficial use of NCSD and TLC's water rights is 347.3 acre feet. And I see that from the table. That's very clear how you calculated that. This represents 1.9% of the total allowable depletion under TROA, which is 17,600 acre feet. And I did find that in TROA. Thus, the total depletion is within the TROA allowances. I guess my question for you, Ms. Wagner, is, I mean, I certainly understand that 347.3 is less than 17,600, but did you do any other accounting or analysis or calculations to determine that this depletion is within the total allowance?
Within the total allowance of 17,600?
Yes.
Well, Mr. Lilly, I'm a little confused about your question, but as stated in my testimony, I used the methodology that's prescribed by DWR and how they, every year when they account for depletion under TROA, and I sort of synthesized an estimate of what depletion would be if Northstar, NCSD, and Trimont made full use of their permitted water and beneficial uses. So if you could repeat your question for me.
Okay, well, I know I'm mainly just trying to understand what you did. But so, and maybe there's nothing more you can say about this, but what do you mean when you say the total depletion is within the TROA allowances?
347 is a portion of 17,600. So what I mean is 347 is less than, but a portion of 17,600.
Okay. All right, so let's go forward, Mr. Anderson, to page 8 on the top paragraph there, and this is sort of a related question. Okay, so the last sentence on that carryover paragraph at the top of the page says the settlement agreement in TROA took into account all existing rights within the watershed, and even at full build out, 1,206 acre feet is well within the total amount of water allocated under TROA. I understand that 12,000 or 1,206 is well within the total amount allocated under TROA, but again, what do you mean when you say the settlement agreement and TROA took into account all existing water rights within the watershed?
Well, it's my understanding that the water being used within the Truckee River watershed and Lake Tahoe, those rights were factored into TROA when the settlement agreement was reached and the water was divvied up between parties, California and Nevada. the amounts that California was given factor in the water that is used and rights that exist within the California side or the Nevada side.
Okay, I guess I'm gonna, how do you know that?
Just 1 second.
It's okay.
Well, I don't know that 100% for sure. That's been my understanding in communications with DWR when who prepares the annual inventory, that they have an understanding of the the water right holders and how the data are tabulated and collected.
Okay, and I guess that's what I was getting at. I have looked at the DWR annual inventories of water use in both Lake Tahoe and the Truckee River Basin in California. And certainly the current usage amounts are way lower than the allocations. They're like 50% or lower. But it seems like our proposed order that my office prepares needs to discuss that some. And, I mean, we can look at those, the DWR annual reports, and we can list the numbers and say that the allocations to Trimont and Northstar, even if those were made, that the amounts of usage would be way below the amounts allocated to California under the Settlement Act and the and TROA. But I just wonder if there's anything more you can say about that. I mean, I think, I'll be candid. I think the order needs to say something about the current usage amounts in California under these different allocations as reported by DWR. And I wondered, I mean, you didn't talk about that in your testimony, and I wondered if you have an opinion as to whether or not that's relevant to the discussion here.
Well, from what I've gathered in the research I've done in the information, there's a little bit of a disconnect. DWR, TROA has allocated amounts and prescribed very detailed methodologies for calculating depletion and use of surface and groundwater combined supplies. And DWR prepares annual inventories that look at beneficial uses. And they come up with an estimate of depletion each year. And from what I've gathered from talking to staff at DWR, they simply report the numbers. So they contact the parties that are involved. So they reach out to NCSD or Trimont, or they get the data. They inform me from progress reports that are submitted, and they punch that into their depletion amounts. And so it's sort of my, belief that the amount of work that's been done to come up with these total diversions allowed under TROA versus how DWR is reporting sort of covers everything, covers all the bases. But there isn't necessarily a direct correlation. Let's see, how do I say this right? Into how these two reports feed back and forth to each other each year.
And I'm sorry, which two reports do you mean?
Sorry, the annual water use reports that are prepared by DWR, and then the annual overall TROA report that looks at hydrology in the system, for the entire system in both California and Nevada.
Okay, I think I understand that. Basically, DWR just says what's happening, and TROA looks at the allocations to see whether we're within the allocations.
Correct.
Okay, I mean, this is significant because the state of California is a party to TROA, and obviously the water board is bound under, as California has signed that. So, okay, well, I think I'm going to ask, at the end of this hearing, I'm going to ask the attorneys to provide some briefing. They haven't filed any. I haven't asked for briefs, and they haven't been filed yet. But I just think some additional elaboration is needed. It's sort of half a technical question and half a legal question, or maybe it's a mixture of both. But I'm pretty sure that the board members of the State Water Board are going to ask, well, how does this fit in? How does, if the board were to grant these petitions, how does that fit into the TROA accounting? I don't think we can just ignore that. So I'll just note that I think some additional analysis and perhaps a testimony is going to be necessary. But I'll circle back, and of course, the attorneys can provide comments. But while I've got you answering questions, Ms. Wagner, let me just check my notes here.
Mr. Lilly, would you prefer that I comment on this at a later time after you have a chance to speak with Ms. Wagner about your other questions?
Why don't you go ahead now, Mr. Cho? That's probably the best bet. Please go ahead and comment.
Thank you. I would just add maybe as to supplement Ms. Wagner's comments that the petitioners looked at this approach essentially as confirming that their use is within the contemplated amount in their permits. They're not requesting to obtain any new water rights or increase the amount that they were already issued under their permits. And as referenced in the letter from the Bureau of Reclamation commenting on the proposed order, I believe it references that there's procedures for implementing this allocation already in place. Petitioners are completely comfortable following those procedures as necessary. And if the hearing officer or the water board wish to include more specific terms or conditions in the amended permits, we would be fine with that as well, whatever is needed to ensure that the TROA and the Settlement Act are followed. But given that the amounts of water under the permits are not being requested to be increased or changed in any way, our assumption was that we could continue to rely on the existing procedures that are in place that protect TROA and the Settlement Act.
Okay, well, thank you, Mr. Cho. But and actually, that does lead to my next question for Ms. Wagner, which you may want to comment on as well. Excuse me, just a minute. Got to turn off my other phone. There we go. The way it works under California water law with petitions for extensions of time is the water board looks at a baseline of basically what would be the licensed amounts if the petition for extension of time petitions in this case were denied. And so that's going to be the maximum amounts that were diverted, collected to storage, and applied to beneficial use before December 1, 1985. That's the deadline for applying water to beneficial use in all four of these permits. So it's not completely accurate, and you can't just sort of gloss over it and say, well, these are the permitted amounts, because the effect of granting the petitions for extensions of time is to allow the permittees to divert more water than they otherwise would be allowed to, just basically because they can go from their maximum beneficial use before 1985 to whatever the current amount is. So actually, that was one of the questions I had for Ms. Wagner. I assume it's Ms. Wagner, whoever's the most qualified witness, but Ms. Wagner seemed to be within your testimony. And that is to provide us I'd say tables or some information of the highest amounts of water that were directly diverted under each of these three permits. I mean, there was no water diverted under 15905. Highest amounts of water collected to storage. I think two of these permits have storage authorizations. One is direct diversion only. and then the maximum amounts applied to beneficial use, all before December 1, 1985. And then what would be the increment of additional diversions and use that could occur if the board were to grant the petitions? I mean, that's really what we're talking about here. And I don't know for sure what the board members will do, but I'm pretty sure they're going to want to know that. And it's basically, how does that increment, whatever it is, it's 1,206 minus the maximum beneficial use amount for December 1, 1985. And how does that fit in to these new allocations that we have under the Settlement Act and TROA? It looks pretty good based on the DWR reports. It looks like there's plenty of water still available under the allocations, but I'm not comfortable simply saying, well, we think that they considered the whole 1,206 when they made these allocations. I'm not comfortable putting that in a proposed order when we have no evidence to support that statement. Ms. Wagner, I know you're very qualified and have been doing this a long time, and I'm not in any way questioning your abilities here, but to just say, well, I think that's what DWR did, just is not, it's not sufficient for us to put that in a proposed order to say that. It's just not substantial evidence. So anyway, I'm sort of rambling a bit, but Mr. Cho, do you have any follow-up comments on that? I'm just telling you what I'm thinking so we get this out and discuss it.
No further comments, Mr. Lilly. Your comment is well taken, and I appreciate and understand the importance of making sure that you're able to rely on information that you provide to the board. So thank you.
Okay.
And
go ahead, Ms. Wagner.
Yes, I would just like to say that that's an excellent question, and I was not asked to do any analysis of historical diversions under their permits, and it's my understanding that NCSD will speak to all of that. Okay.
So looks like Mr. Martin and Mr. Detweiler, you're going to be put on the hot seat here. I'm not going to ask you today, but just so you know, and I understand there's no way you can, or maybe you can. I was going to say you can't possibly pull the numbers together, but Mr. Martin, go ahead.
I do have our NCSD diversions going back to 2010 in front of me now. So we do have this information and we can provide it.
Yeah. And just so you know, we have posted copies of the permittee progress reports that we copied from the water right records unit's paper files. For some reason, we didn't have them for the last application, the application 23851. Either we didn't have them or we lost them, but we will get those, and they are in the administrative record documents that we have. But and I'll circle back to this, but I think there is going to have to be some analysis of what I'll call what would be the license amounts if the petitions for extensions of time were denied, versus then what is the increment of use that could occur, maximum increment of use that could occur, excuse me, if the petitions are granted. And then how that fits into the Settlement Act and TROA allocation. So I'm probably not articulating this as well as I can, but hopefully you all get the idea of what I'm talking about. But I am almost certain that the board members are going to ask about this. And if we just give them if my staff and I prepare a proposed order that sort of glosses over this, I think it's going to get sent back to us for further work. And obviously I don't want that. So, and frankly, you don't want that either. You want a very solid defensible order. And this is a golden opportunity for you to get an order approving the districts and Trimont's petitions, but where you don't have significant opposition, and you can sort of turn the clock forward, I'll say 35 years and move forward from here. So we want to get this right. And if it requires a little more work, it's going to be worth it. So anyway, I may circle back to this. I'm a little disorganized with my questions here, but I just wanted to let you know that's where I'm coming from. I did have a couple of other questions for you, Ms. Wagner. Sorry to keep you on the hot seat here.
Okay.
Mr. Anderson, if you can put up Exhibit Trimont Northstar 13, please. Our normal staff member who handles posting exhibits is on vacation this week, so Mr. Anderson is pinch hitting, but he's doing quite a good job, I will say. Thank you. If you can go to page 2 and down to, right there, right, stop there. This is just a simple question for you, Ms. Wagner. Yeah, just scroll up a little bit. There, that's good. Page 1, question 4. What is the anticipated maximum rate of diversion from each off-stream source into Sawmill Flat Reservoir, which is Reservoir A? The last sentence there, Ms. Wagner, says maximum anticipated rate of diversion would be 1.44 cubic feet per second, which is based on the snowmaking manager. I just want to flag for you all 3 permits, the 15906, 16619, and 16618, have a 1.35 CFS limit on diversion to off-stream storage. And I don't think we have any way to raise that. I think that would be increasing the water rights. So I don't know if you have any comments on that. It's just a little bit less than what's in here, but those are the permitted amounts for diversions to off-stream storage. So Ms. Wagner, do you have any comment on that?
The only comment I have is that number is purely hypothetical based on the combined pumping rates. It's my understanding that there is not that amount of supply that there. So that is just simply what the facilities are able to do, not necessarily what we anticipate, I guess. So that's an incorrect sentence, maximum anticipated rate of diversion. Maybe it would be better off if it said,
just facilities capacity.
Yes.
Something like that.
Yes.
Okay. Well, thanks for the clarification. And I just flagged that. I mean, I don't, obviously Trimont and Northstar are very responsible entities and will want to comply with their permits, but I just flagged that there is a potential risk there of slightly going over that number. Okay, so then Mr. Anderson, if you can go to Trimont Northstar Exhibit 10, Exhibit Trimont Northstar 10. And just go scroll down to the bottom of the first page. There, thank you. And this is the sort of thing that bothers me, Ms. Wagner, as an attorney. Attached, it's the very second to last line, attached is figure 1, map showing water right facilities. And maybe I missed it somewhere. I could not find figure 1. Do you know where it is?
It's my understanding that figure 1 is now Exhibit 6.
Oh, okay. So that is now Exhibit Trimont Northstar 6?
Yes.
Okay. I thought it might be, but I thought I better check.
Do you have any?
All right.
Yeah, that is figure 1.
Okay, thank you. And then Mr. Anderson, if you can go forward to page 4 of that exhibit. Page 4 of exhibit Trimont Northstar 10. Looks like, there it is. And down, scroll down to the bottom of the page, bottom half of the page. Okay, that's good. So, Ms. Wagner, the very last sentence or section here talks about Big Springs Collection Gallery, Stan's Dam. And then it talks, actually, the sentence that starts there, the MMC also collects water. And then if we can go forward to the top of page 5. And we just scroll down to the top of page 5. Well, I'll read it while he's trying to scroll it down. That is diverted at Stan's Dam. And then it says Stan's Dam is located on an unnamed stream adjacent to the Big Springs Collection Gallery. I guess my question for you, Ms. Wagner, is I don't think Stan's Dam is listed as authorized point of diversion in these permits, and is that an issue or a problem?
Mr. Lilly, this memo documents what I observed on the ground on the day that we visited Northstar and learned about their system. It's my understanding, based on discussions with NCSD and Trimont employees after I compiled this memo and address this concern with them, that Stan's Dam is not part of our project and is not integral to the collection system of water that is routed to the Big Spring cistern. So while it is existing and is on the ground and it is there, they are not utilizing it to divert water. Or they do not intend to utilize it to divert water for their permits.
Okay. Well, again, they're not going to be authorized to, so it's a good thing that they're not planning to do that. You know, and it would be a little bit of a challenge to add a POD now when it wasn't in the notice for the petitions, but I did just want to note that there's potentially a problem there, but it sounds like they have addressed that. So, okay, so those are all the specific questions I have about the exhibits. Let me just go down my list of what I have, and I will send out a post-hearing notice with these things in writing so you all have them. So if you don't get it all written down exactly now, don't worry. But I do think we're going to need an additional day of hearing. I would like some additional written proposed testimony and exhibits as necessary, and then another hearing, which probably also can be fairly short, maybe even a little shorter. But let me just go down the list of things that I have that I think I need before my colleagues and I can prepare a proposed order and transmit it to the board for the board's consideration. And again, these are sort of just in the order of exhibits. So I'll start with you, Ms. Walsh. In Exhibit 1, you on page 9, we don't need to put it up there, but you reference Reservoir B, and I asked you a question about that earlier. I would like you, I think you're the logical person for this, to prepare a plan and proposed schedule for development of Reservoir B and the related infrastructure. I'll say, I don't think at this point the proposed order can extend that time after 2028 because that's all that was noticed that's all that was asked for in the petition and all that was noticed in the notice. But we have some pretty sophisticated board members, including an engineer who was in the Division of Water Rights before he went to the board. And I think he's very likely to ask, well, what's going on here? So I think we need some evidence as to what is the Trimont's current plan as necessary. And, and it's not the end of the world if they have to apply for another petition or file another petition for extension of time for a municipal system. The law allows some leeway in that, but it's a loose end that I think we need to clarify. So I'd like you to provide some testimony on that. We've covered, Mr. Martin and you, Ms. Walsh, have covered my next question, which was explaining what Northstar does versus what Trimont does with the purposes of use and places of use. So we don't need anything more on that. The engineer's certificates are covered. Figure 1 is covered. Stan's Dam is covered. Oh, so Ms. Wagner, I did have another question. If we can go to Exhibit Trimont Northstar 10 again, Mr. Anderson, and to pages. Oops, I don't think I wrote down the right. Oh, it must not be 10. Whoops. Hang on here. The exhibit, I think it's one of your exhibits talks about CEQA compliance. Is it 13? think it's 13.
Mr. Lilly, I think it's 15.
15. That's why I haven't found it. Yeah, it must, I wrote down the wrong number in my notes, but it must be 15, exhibit 15, pages 11 and 12.
That memo is only 5 pages.
This is my, I just had it here and I just wrote something down wrong. I wrote down pages 11 to 12, but I got the wrong exhibit number. I just want to find the one that talks about the CEQA documents. Yeah, here it is. It's exhibit 8, your testimony. Mr. Anderson, please put up exhibit Trimont Northstar 8. And go to page 11. There we go. If you can scroll down, down to about question right there. It's this, my question, Ms. Wagner, is what your question was to you was what documents were you able to review and coming to your opinions contained in the CEQA technical memorandum? So now I'm trying to remember what is the CEQA technical memorandum that's referenced here?
That would be exhibit 15.
Okay, that's where I'm getting a little befuddled here. Okay, sorry. So it's pages 9 and 10, or excuse me, pages 11 and 12 of exhibit 8, exhibit Trimont Northstar 8 talk about CEQA, and then the technical memorandum exhibit Trimont Northstar 15 talks about that. And my question for you, Ms. Wagner, is do the project descriptions in any of these CEQA documents refer to the petitions for extensions of time or change petitions that are the subject of this hearing?
No, they do not.
Okay, I couldn't find them either. So the question for the attorneys, Mr. Cho, and I think Mr. Taggart, is how can the obviously the State Water Board is a CEQA responsible agency here and relies on these CEQA documents for the board's CEQA compliance, and how can the board do this, or what does the board need to do to use these documents for the board's CEQA compliance when the project descriptions do not refer to these petitions? So I don't expect you to answer. I mean, if you can answer that right now, great, but I suspect you may want to prepare and file some briefing on that.
I'll take this first, and if Mr. Taggart or Mr. O'Connor, you want to jump in as well, feel free. The state of the CEQA review of these petitions, as Ms. Wagner stated, the petitions are not directly referenced in any of the cited environmental review documents. This proceeding is a little nuanced in that, as you understand, these are sort of holdover petitions that were originally filed back in 1985. And so and with some minor updates for lining up with current times. And the water rights themselves and the contemplated build out have been analyzed in the cited CEQA documents. If it is the preference of the AHO, the petitioners would be happy to provide further information that directly references these petitions. We would ask that the record simply be held open for that time, in which the petitioners can go ahead and prepare some additional documents that cite these petitions, and the change, particularly the extension of time that is sought, and the other changes as well. So if that's the pleasure of the hearing officer, we can do that.
Okay, well, what I'm going to propose that you, and you can work with Mr. Taggart and Mr. O'Connor as appropriate, but I'm going to, again, maybe this may sound lazy on my part, but you can do this better than I can, but I'm going to ask you to prepare a proposed text for the order, for the proposed order, a new section with proposed text that describes how these documents are sufficient for the board to satisfy its CEQA obligations. I mean, that's rather than you making arguments and me turning them into a proposed order, since we don't have any other parties, it's easier for you to prepare the proposed text. Of course, we may edit it, but I think that'll be the most efficient way to go forward. But I do think we need a section on, I know we need a section on CEQA in the proposed order that talks about this. And there may be something fairly short on CEQA now, but I think it needs to be beefed up on that.
Mr.
Let me just
Lilly,
check. Oh yeah, you do have status of CEQA compliance here on pages 12 and 13.
Mr. Lilly,
Yes, go ahead.
Kevin O'Brien, if I could just supplement Mr. Cho's comments. I think this is a somewhat nuanced situation from a CEQA compliance standpoint. And in our internal discussion and review of the CEQA issue, our initial position and our client's initial position has been that that an exemption would be appropriate based on the fact we're dealing with existing facilities. I fully recognize that that might be perceived by the AHO as a somewhat aggressive position, and rather than spend a lot of time on briefing the question of whether there's been adequate CEQA compliance, if it would be your preference to have Northstar Community Services District prepare an initial study and go through the process that I anticipate would culminate in a negative declaration, we're certainly willing to do that. So I just want to make that offer so that we don't spend a lot of time and a lot of your time going in circles on this issue.
Okay. Well, and I do have to confess, I previously read section 4.1.5 of your proposed order, which talks about CEQA compliance. So let me look that over and see whether I think you or I need to, I mean all of you, need to expand that or talk about these documents in more detail, or whether I can. I appreciate your offer to do a new initial study. I don't know that that's necessary. I guess if the board adopts this order and no one challenges it, then CEQA has been taken care of. So let me look at that further, and I will include what I think is appropriate in this. I will say a notice of exemption, I do not think the board wants to do because there's no lead agency and responsible agency for a notice of exemption. So the board has to make independent findings on that. And I don't think here the board really wants to do that. I think the board would like to stay in its role as a CEQA responsible agency and have Northstar CSD be the CEQA lead agency. So let's do this. I will read over that section again and see if I think it needs further detail. And if so, I may ask you to do that. And if I don't think that'll be sufficient, then I'll consider your offer to do a new initial study. It either could be an initial study, neg-deck, or potentially it could be an addendum to some of these prior EIRs. I'm not sure which way, but that would be up to Northstar in its discretion to decide what to do. So anyway, but thank you for your clarification. Let me see how I think we can get through this.
Thank you.
Okay, and then I did note on my checklist, Ms. Wagner, I do want you to prepare tables of the highest amounts of annual diversions, instantaneous diversions, collection to storage, and beneficial use amounts for the 3 permits before December 1, 1985. So the maximum increases in these amounts that could occur if the petitions are granted. And then related to that, I just downloaded yesterday the DWR annual inventory of water use reports for Lake Tahoe and Truckee River basins, and I will add those to our administrator record, which is on our AHO FTP site. But I would like you to provide, and probably the easiest way is just do a new technical memorandum that talks about both these issues, the historical use amounts, increments, and how those fit into the allocations under the Settlement Act in TROA. And again, I'm sorry if I'm being difficult, but trust me, a little work now may save us all a lot of work down the road. And I am definitely not the final decision maker here. And, and the Truckee River is such a sensitive issue. I mean, I guess all watersheds in California are sensitive in different ways, but the Truckee River is no exception. And I know we're going to get scrutiny from the board, so I want to make sure we've done everything we can to satisfy their questions, which will be legitimate questions. Okay, so that I will follow up with that in my follow-up order, post-hearing order. Just a couple of other housekeeping matters. The Exhibit 19, Trimont Northstar 19, is a February 10, 2010 letter. But it's only page 1 of the letter. I think it's a letter from the board, and we could probably dig it out of our files. But I'm wondering if one of you could just get the whole letter and email it to the AHO webpage, and we can substitute that. I don't really like having the first page of a multi-page letter as an exhibit, because it leads me to wonder what, number one, who signed the letter, and number two, what is on the other pages of that letter. So Mr. Cho or Mr. O'Connor, can one of you just get us that whole letter and save us having to dig it out of the paper files?
Yeah, that shouldn't be a problem. And this is actually already in the AHO file. The reason it wound up as a one-page letter in here is because it was referenced in Mrs. Walsh's testimony. So we wanted to have the paragraph referenced in the testimony also available. But this is something that's already in the AHO's file for this hearing.
Oh, now I'm embarrassed to say I looked. Of course, there are a whole bunch of different folders. I could not find it. If you can just, that's even better if you can just tell me where it is. I'm embarrassed now, but my bad. Go ahead, Mr. Cho.
I can tell you right now, if you were to open the folder for application 23849.
Okay.
And go through chronologically, it's under 2010 0210 K Moralka letter to S Somac, and that copy of the letter is also one page, and that was what we pulled our exhibit from. So your office may have better luck finding the original. We can certainly endeavor to try to locate a fuller copy if there are additional pages, but we don't have. I don't believe we have a paper copy of that letter.
You're embarrassing me right and left here. I apologize.
Not my intention.
No, it's fine. Don't worry about it. Number one, I didn't look in that. I looked in some of the application folders, but not that one. And number two, if we're the ones who put in an incomplete letter, I guess I shouldn't be so critical, should I? So I think maybe that is our responsibility to see it. And it may very well be that that's all that's in the Water Right Records Unit's paper files. But let's do this. If you can check your files and see if you have the other pages, please do that. And then just let me know either way by email to the AHO email box. And then we will check the Records Unit paper files to see if we can find it. It may be we just didn't copy it, or some accidentally. We will. Let's try to get it together and just get that cleaned up.
And Mr. Lilly, just while we're on this letter, if I can put it on the record, the first page is sort of of course, we want to have a full letter if possible. The first page, the piece that we thought was important for this hearing is the description of how the permits were issued in the past, because the files are sort of littered with memos and that sort of thing, and it's hard to put together a full picture of the intent of these permits originally. So I just call your attention to the second to last sentence in the second paragraph for this letter. That's really what we're referencing here. So in case you're wondering the point or the purpose of this single letter, it points out that the second two permits that were issued, they use the term to provide operational flexibility. So kind of the point again for this, and maybe we can get it just from the front page of this letter, is to point out that these four permits, at least it's our understanding, when they were originally issued, the four permits can kind of work together and feed off of each other because they are all similar water sources of snowmelt runoff and groundwater sources and that sort of thing in the area. So again, the intent of it is to show that all four of these permits, we believe, were originally issued to operate together, almost as multiple points of diversion. And that was the purpose of this page of this letter.
Yeah, and that's fine. And obviously, it's just nice to know who signed it and all that. And it looks like it was our problem or mistake to begin with. So we'll see if we can clean it up. But if you can find it and save us time, that would be nice.
Great, we'll do what we can from our side.
The next one, and I do think this is one that's your responsibility, although you may point out that I'm wrong. Exhibit 28, Trimont Northstar 28, is a very long CEQA document. And when I was going through that yesterday, I flipped through the title page and the table of contents, and then it immediately went to part 10. And then down farther, way down in the document, it went back to parts or chapters 1 through 9. So I'm wondering if you can just see if you can get a new version of Exhibit 28 that has all the pages in the right numerical order. It just will be a lot easier to follow. And I'm pretty sure that it's a problem. I had Mr. Anderson checked, and he confirmed that he also found that the pages were out of order. So whichever one of you is responsible for that, if the best thing is just upload it. That's too big to email, I'm sure, but just upload it to the AHO FTP2 site and send us an email, with copies to everyone on the service list, of course, when you have done that. And then we'll just substitute that for the current version of 28, just so we have one that has the pages in the right order.
Great, that shouldn't be a problem. We should be able to get that fixed.
Yeah, I mean, we might be able to do it, but you'll be able to do it a lot better than we can. It is your document, so go ahead.
Sure.
Regarding the proposed order, which I do appreciate very much that you sent that to us, that'll certainly save us a lot of time to start with. Can one of you transmit to our AHO email inbox a Word file of that order? It's going to be a lot easier to edit than if we have to try to make a Word file from the PDF.
Yes, I can do that.
I think we got it in PDF before. Mr. Cho, can you do that?
Yes, I can. Would you prefer that to be emailed or similarly uploaded to the FTP?
I think you can just email that. Usually the Word files are not very many megabytes.
Of course.
So thank you. Okay, and then for the attorneys, in the proposed order on pages 9 and 10 in section 4.1.1, this is where your draft proposed order talks about the elements in California Code of Regulations, Title 23, Section 844, which is the regulation that applies to petitions for extensions of time. I would like you to provide additional text, and you could please coordinate with Ms. Walsh, because this concerns the request I had for her to provide testimony on this. But I think we need to have some significant additional discussion of how these factors apply specifically to permit 15905 and Reservoir B, because that permit was issued over 40 years ago, and there's been no construction and even plans for construction of that yet. So I think you can argue it's part of an overall plan of development. I mean, it certainly makes sense from a municipal water supply point of view that first you develop the least expensive water supplies, and then as necessary, you have an additional source, which you will develop as necessary. But I think the order will be much stronger if it discusses how those three factors in that regulation apply to that permit in particular. So I'm not sure who is doing that, but please coordinate with Ms. Walsh so we have both testimony and proposed additional text for the argument for the order. The easiest thing is just to submit, maybe just submit a new section 4.1.1 with that additional text included in that. Does that make sense?
That does make sense, Mr. Lilly. I guess this sort of goes back to your first point. Maybe I'm asking for a little clarification here regarding the testimony. You had asked for a little bit more testimony to beef up the plans for RESB and that sort of thing. And you had asked about the timing for extension. So I guess I'm just trying to get you exactly what we need here. From our point of view, I think what we applied for was the maximum amount of time that can be granted on an extension, unless I'm just off base on that. And that's where this 2028 date came from. And we're now 3 years down the road because the paperwork was filed in 2018 and now we're in our hearing. So I guess I'm wondering if you're looking, for a full schedule that goes to what we anticipate the full build out might be, even if that's, say, just putting a random date on it, but say it's 2035, or if you're looking for more of a schedule just up through 2028. One of the practical difficulties we face here is that the permit, has been pending in limbo since 1985. And so it's hard to, from my client's perspective, it's hard to allocate resources and time and that sort of thing to a permit, which they don't know what the status is for the last 40 years, kind of like what you said. I think we agree with you there. So I guess I'm just looking for a little clarification on what the hearing office would like to see, knowing that it's a 10-year extension and that's where the 2028 date comes from, but that might not be a realistic goal for a full build out of a reservoir on a permit that has been in limbo for 40 years.
Okay, well, thank you, Mr. O'Connor. First of all, and you might want to discuss this with Mr. O'Brien or Mr. Cho, but the 10-year rule actually only applies when the board's executive director or somebody delegated under her is issuing an order for extension of time. When it's going to the board anyway, the board can grant an extension for more than 10 years. So I don't want you to say the wrong thing in your submission, but just live and learn. In hindsight, you could have asked for more time because this clearly always had to go to the board under the permit terms. So there was the 10-year limit did not apply. But that's, you did what you did and we can't change that now. But to your bigger question, please just look at the 3 factors in the regulation. It's Title 23 of California Code of Regulations, Section 844. And the 3 factors, which are discussed in the proposed order text that you submitted. Number 1 is due diligence has been exercised. Number 2, failure to comply with previous time requirements has been occasioned by obstacles which could not be reasonably avoided. I think that gets to your argument that you couldn't really figure out what to do until the Truckee River Settlement Act and TROA the act was enacted by Congress and TROA was signed by the parties. And then 3, satisfactory progress will be made if an extension of time is granted. I mean, I'll just say, I think you need to front on candidly address the issue that you are likely to need an additional extension of time beyond 2028. Because the board sometimes, they can get pretty tough with these things and basically say, okay, well, we'll grant you this extension, but we're not going to ever grant you another one. And that would put you in a difficult situation. I mean, just realistically, I think it's pretty unlikely you're going to get this done in 6 years. And you may not have the demand for it in 6 years. So and then the reg goes on to talk about lack of finances, occupation with other work, physical disability, and other conditions incident to the person and not the enterprise will not be generally accepted as good cause for delay. Now, there are board orders on extensions of time for municipal water supplies, particularly Order WR 2000-13 involving the city of San Luis Obispo, and I'm sure Mr. O'Brien can help you on this. But I think you need to do some work here and explain what the plan is and why it's appropriate for the board to grant this petition for extension and why there potentially may need to be more extensions. I mean, the law and the board do give some leeway for municipal supplies because obviously the demand typically develops over time. And that's exactly what's happening here. As there's more build out, the demand goes up. But it's important for you to make this proposed text as strong as you can and supported by evidence.
Of course. Okay. I think that clarifies it. Thank you.
Okay. My next question, and again, bear with me, but as I say, I'm trying to be constructive here. I don't think any of the attorneys, I'll just ask, did you make any amendments to the draft amended permits we submitted to you, which you added as attachments A through D, or did you just attach those in the format we sent them to you in?
Those are attached in the form that you provided.
That I did not see any changes, so that's what I thought. And frankly, I thought you might want to make some changes. I was a little surprised, but maybe you didn't want to rock the boat. But let me just tell you about one term that I think you may want to consider. In the first permit, 15905, term 10, term 10 says no water shall be diverted under this water right until right holder has established a permanent organization which will, to the satisfaction of the state water board, properly operate and maintain the water supply system. And there's a similar term. It's term 10 of amended draft amended permit 16619 and term 16 of draft amended permit. I'm mixed up. It was term 16 of permit 16619 and term 10 of permit 16618. I think it has the exact same language. And as far as I can tell, the board back when they issued these permits in the 70s and 80s put that in because they were concerned that some fly-by-night developer might develop a water system and then go bankrupt or leave, and the houses would not have an adequate water system. And obviously, that's one of the reasons the board encourages public entities like Northstar CSD to run the water systems. You have this hybrid system now, which makes sense. I'm not criticizing that. But I think with some evidence from Ms. Walsh and Mr. Martin and some argument, there may be justification for removing those terms from those three permits, which I think would be in your interest. But I need a little support to do it. I'm not going to just, I almost have enough now, but I think a little evidence on that. And basically that for the municipal component, Northstar CSD is in charge. And of course, it's a public entity and what they call a permanent organization in here. So I think that will be enough. But I'd like to take those terms out if we can, because obviously water has been diverted under these permits all these years. And I think that would be helpful. So I'll just throw that out there. We may have to amend it for permit 15905 because that permit is held solely by Trimont and has not been developed. So I think it's a little harder to say that's under the umbrella of Northstar CSD. For the other two permits, I think it's easier to take the term out completely because Northstar CSD is running the municipal components of those. But anyway, please take a look at that. If you don't want to do anything, we'll leave them in. But I think it might help you or be beneficial to you for us to take those out.
We appreciate that, and I certainly welcome your assistance in that. As you surmised, we didn't want to unnecessarily rock the boat. I viewed that term as being satisfied already by the system that's in existence right now, being maintained largely by NCSD. So we assumed that was a satisfied term and that it may not be necessary to remove, but for the reasons you stated, we'd be happy to address that and propose an amendment to the amended permits.
Okay. And Mr. O'Connor, I think I think for permit 15905, it can't come out, but it should be amended. Because that permit is held solely by Trimont, has not been developed yet. So it's harder to make the argument that that's under the Northstar CSD umbrella.
Correct. So we'll look into that from our side, and we will come back to you with some information.
Okay. All right. The next, and bear with me, I'm almost done. I looked over the Truckee River operating agreement, which is an interesting read. Must be about 250 pages long. I didn't read the whole thing, but there are a few sections that I think may apply here that talk about what the water board needs to do when it's issuing amended permits. And it's a little confusing as to exactly what applies where, but I think, the Bureau of Reclamation suggests we have a general term, which I think makes sense, that the permits have to be consistent with the Settlement Act and TROA. But let me just flag these specific sections. And again, I will put this in my notice and you can tell me what you think. But I think we need to add some permit language to the amended permits. And we didn't have time to do this before, but take a look at TROA. And I'll just read these off to you, but I will put them in the order as well. It's section 6C1, subdivision E, 6C2, B2, and there's text there after subsections Roman numeral 1 and Roman numeral 2, and then section 6C3A and 6C3B, and then which would apply to permit 15905 and Reservoir B, since they haven't been constructed yet. And it talks about new facilities, not making a distinction whether permits have already been issued. And then section 6E1E3, which applies to Northstar, specifically to Northstar's diversions for snowmaking that carry water from the Truckee River Basin into the Lake Tahoe Basin, and put a limit of 20 acre feet per year on that. So I'd ask you in your briefings, I don't think you need any testimony on this, for your briefings to let me know whether or not you think we need to add permit terms to address those sections of TROA, and if so, to prepare a proposed language for those permit terms. And we'll take it from there. Okay, so that's all I've got for now. My plan is to issue a post-hearing conference order and set another date. So I would like to talk to you, all of you, about scheduling for how soon I hope this gives you a fairly good idea of what I'm looking for, what schedule it is for you to, reasonable schedule for you to complete these written submissions, and then for me to, then a hearing date for some time after that. Probably again, 2 hours will be all we'll need. But how much time do you want to do these things before we get to the hearing?
Mr. Lilly, before we jump into that, I had one more question on permit terms.
Of course, please.
Completely. So let me try and preface it with some background. The first two permits, 15905 and 15906, were issued in decision 1342 from the State Water Board. That decision included a requirement that the permits have a hearing anytime an extension of time is requested on them, which leads us to where we are now, of course. That was a permit term that was put into those permits, which was not in the draft permits that we have in front of us now. So our question was, are we looking to strike that requirement from the old decision now that TROA has been implemented, or are we going to maintain that permit term?
As far as I'm concerned, this hearing satisfies that term, and that term then becomes obsolete.
Okay, and that was our view also, because it was our understanding that that term was largely based on TROA being drafted and implemented. So our understanding is the same. We think the draft permits reflect that understanding, but I wanted to make that clear when we were talking here today.
Yeah, and that is why I asked a little while ago this morning for the additional information regarding the increment of additional water use and how that fits into the TROA accounting, because I think it's pretty clear. I mean, who knows for sure, but it appears that that's why the water board included those terms, because they wanted to make sure that extensions of time would not cause California's water usage to go over its allocation, which of course they didn't know what it was going to be back then. So I think if we take care of that with the analysis of the increments for the extensions of time, then we no longer, and of course we now have the Settlement Act and TROA, it's no longer necessary for that term to be in. So that's why we did not put it in the amended permits. We did think about that, but thank you for asking.
All right, great. Well, with that, I think we're ready to move on to schedules then.
Okay, so I was an attorney for many years with lots of clients and trying to fit water board hearings in. So I do appreciate the fact that you're all probably all fairly busy and we have a drought going on too. But on the other hand, I don't want this to drag on. I think it's in all of our interest to get this resolved as soon as we can. So what's a reasonable time for all of you to get together internally without us and prepare what I've asked for in forms of additional testimony and briefing? And what's a reasonable deadline for you to submit that back to our office?
Well, Mr. Lilly, I'll just posit that one determinative factor may be whether our current explication of the CEQA status is sufficient for your purposes, or if we'll need to go back and provide some other additional documentation that may change the timeline.
I think that's a very reasonable question. So let's go off the assumption that you can edit this section 4.1.5. Let's go off the assumption that I read that and say, I think you need to provide some additional text in there, but you can do that based on the existing CEQA documents. And it might be in terms of, listing them in a little more detail and describing what they analyze and so forth. But let's go off that assumption, Mr. Cho, to start with, that you can do that and Northstar CSD does not need to prepare any new CEQA document. Does that help you for thinking about time scheduling?
Yes. And I'll defer to Mr. O'Brien, who I think has a much more populated calendar than I do, and probably a better sense of timing requirements that we might have for this as well.
He's going to just make you do all the work anyway.
I'm comfortable with that. Not comfortable as much with just laying out the calendar as on my own. Thanks.
That was a light comment. Go ahead.
I think given other crush of business, probably 60 days would be reasonable, Mr. Lilly. And that would also give us time if we need to. Frankly, I like your idea that maybe an addendum to the prior EIRs might be appropriate, and that would give us time to complete that process and the other items that you've requested. So I would think about 60 days.
Okay, so let's do that. And Mr. O'Brien, if you, Northstar, you and your client, Northstar CSD, in collaboration with Trimont, conclude that an addendum is the way to go forward, and I really think there may be some CEQA scheduling requirements for that. If you can't get all that done within the 60 days, but you can at least get the proposed addendum filed, then we know where we are and we'll have some progress. I mean, try to do as much as you can, but let's do that. Frankly, I'll just say, I think an addendum makes a lot of sense here too, because then you, rather than putting it in a board order with, where the board doesn't understand all the details of these prior CEQA documents, Northstar CSD, as CEQA responsible agency, can lay it all out, referring to its prior documents and make its own findings, and then the board can simply adopt those findings. So I think that probably will make a lot more sense than putting it in the order. But that's going to be your call, your and your client's call. But I understand then you have to get on board meeting cycles and things like that. So let's target 60 days. Mr. O'Connor, can you live with that? It sounds like I'm not sure who's doing the most work here. I think it's probably fairly evenly divided, but is 60 days okay with you for the deadline for submitting the new documents?
Yeah, 60 days should be great. Thank you.
Okay, so that'll be approximately the first week in October. I think, do I count right? For now, August 6th. So that would be like October 8th. I never know whether I'm doing attorneys a favor or making it harder for them if I make things due on a Monday rather than a Friday. Having worked many weekends myself, which do you all prefer, October 8 or October, which is a Friday, or October 11, which is a Monday?
October 11th.
Oh man, there's a voice of experience. Mr. Cho, you just found out what you're doing the weekend. I'm sorry, I'm not even going to say that. We'll make it October 11th deadline. Sorry, I'm getting late here. And then let's just go ahead and set a potential hearing date. We'll set it for 3 hours, which should be plenty of time. And let's set that for the week of October, looks like 25 through 29. Are there good days or bad days? I'm pretty open. I guess I'd say how about October 29? Does that work for all of you? Hearing no objection, we'll set it for October 29 from 9 a.m. to 12 noon. I don't think we'll need that much time, but let's have it. And we'll see where we are at that point. And so I will try to memorialize this in an order, a post-hearing order, which I will write today, but probably will not be able to get out until Monday. But I'll get it out as soon as I can, and we'll go from there. Okay, anything else for today? I know I've sort of laid on a lot of stuff, but any other questions, comments, or other things anybody would like to mention today?
Yeah, Mr. Lilly, sorry, we were looking at our calendars here for that hearing date. October 29th is a Nevada holiday. Things are kind of shut down here in Nevada. Could we make it?
I'm sorry, what day do you want?
The 28th, just the day before would be fine.
Okay. Tell you what, can we make it the 27th? I have a conflict between 9 and 10, either October 27 or we could start on October 28, but I would not be able to start until about 10:30.
That works for me.
Mr. Lilly, when you mentioned the 27th, morning or afternoon?
I was going to say morning. I mean, I'm flexible either one.
Okay, I have an argument that I have to do in court that morning. So I'm not available the morning of the 27th, but I am available in the afternoon of the 27th.
All right. I assume, Mr. O'Connor, that works for you?
That works great for me.
Mr. O'Brien, Mr. Cho, I feel like an auctioneer. October 27, 1 p.m. to 4 p.m.?
Yes, that works.
Okay. Just saved us a lot of grief going back and forth. We'll target it for, then I guess I'll ask my staff. Mr. Anderson, can you just check and make sure we don't have any conflicts that day on our calendar? I'm going to see if I can get our calendar up here too. I don't have anything on my paper calendar, but I just want to check the electronic calendar. Yeah, that looks, I don't see anything. Mr. Anderson, do you see anything on that day on ours? You can go off mute.
No, I do not.
Okay. All right, that looks good. I'll have to say, it sure is nice not needing to reserve hearing rooms. This used to be a pain for us. There never were enough hearing rooms in the Cal EPA building to do this, but we don't have that problem anymore. So we'll tentatively do that. I will try to get the order out as soon as I can. I'm going to, send it to everyone on the service list, of course. And I'll probably send it out to the AHO Lyris list just because that's what we do with hearing notices, although I don't think anyone else is interested. And if any of you have any questions or comments, please the easiest thing is just send us an email at our AHO email address and CC the other parties on the service list. I know that the people from Reclamation have been observing, and they certainly have a right to do that. So make sure to continue to CC them on anything you serve in this matter. So, okay. Well, that's a lot for this morning. Have I missed anything? Anything else anyone wants to follow up on?
I have a brief housekeeping question, I guess, just in terms of the next hearing. Will the order that you issue from this hearing specify whether or not we'll need to file new notices of intent or have witnesses appear? I guess it may depend on the written materials that are submitted, but do you have any preference going forward on that?
Yes, good question. And the answer is no, you do not need to file new notices of intent. I'll make a note of that and try to remember to put that in the order. And yes, the witnesses do need to appear because they will need to, at least the ones who are submitting new testimony, because they will need to affirm their proposed written testimony during the hearing. And you know me, I probably will have questions. So I want them to be able to be available to answer questions. I don't think anybody who, well, probably all of you, right, at least Ms. Walsh, Mr. Martin, and Ms. Wagner will be submitting additional testimony. Mr. Wagner, unless you have anything else, I don't know that you need to appear. But whoever is submitting new testimony, and at least for Ms. Walsh, Mr. Martin, Ms. Wagner, I'd like you to all be available because even if you don't submit something, I could have some follow-up questions. So does that answer your question, Mr. Cho?
It does. Thank you.
Okay. Yeah, thank you. And again, I'm sorry if you all think I'm being a little persnickety here, but this is an opportunity to get out a really good, solid order, and I want to take advantage of it and make sure, of course, we want all our orders to be solid, but I do want to make sure we've covered all the details we need to here so that hopefully the board will approve this and you won't have to come back to the board for another 35 years. Well, actually, sorry, except Ms. Walsh is going to have to come back in 2028. But maybe not a hearing if nobody files a protest. We'll see. That's down the road. I don't think I'll still be working then, but we'll see. So, all right. Thank you all very much. Anything else for today, or are we done?
Nothing further from Trimont. Thank you.
All right. Well, thank you all for your patience, bearing with all my questions today, and I'll look forward to your submittals on the October 11 and to talking to you all